First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We have one case on the docket today. That is Walker Davis Jr. versus State of Florida. It is 22-30-10. We've allotted 15 minutes per side. Mr. Lombardo, are you ready? You may proceed.
May it please the court, Peter Lombardo on behalf of Walker Davis Jr., and I would reserve 5 minutes for rebuttal. Some things, the operative facts in this case that are why Walker Davis Jr.'s case needs to be reversed is the foreman of this case, Stephen D. Cook, did not disclose on his questionnaire or in questions during the jury selection that he had a prior record, that he had a pending VOP warrant for a DUI, and most importantly, he had 6 pending undisclosed misdemeanors in Okaloosa County, which is the county where Walker Davis Jr. trial was happening. So he was sitting on that. In Florida Statute 40.013, no person who is under prosecution for any crime shall be qualified to serve as a juror. Now, there are some exceptions. There's some case law that talks about if it's a 17-year-old, well, you know, that doesn't go towards bias of the juror.
Mr. Lombardo, it seems reasonably sure that there was misconduct on behalf of this juror, correct?
I'm sorry?
The record establishes it's pretty clear that there was juror misconduct in this case. Okay, but I think your first hurdle is going to be whether you're procedurally stopped, because, you know, the defense may have not been able to discover this record maybe before the trial, but certainly right after the trial. And here we are some 24 years later, and you're bringing this in the 4th post-conviction motion. Why are you not procedurally stopped? Why was this not discoverable sometime in around 2000-ish?
Walker Davis was incarcerated the entire time, up until the trial, during the trial, after the trial. We don't know what 1996, we don't know what was on the clerk's website. As you saw, Mr. Davis did testify. He has no legal training. Most lawyers don't know that someone is ineligible to serve on a jury if they have charges pending. People who go to trial, lawyers who do know that. As far as there's no law, there's no statute, there's no rule, there's no case law saying that lawyers or defendants have to search the jurors and their misconduct. He just came upon it in 2019, so it was newly discovered evidence. He filed it within 2 years of finding out in 2019. There's a manifest injustice. That can be kind of like correcting an illegal sentence. That can be raised at any time, and that's why it's not untimely.
Well, counsel, but the standard does require due diligence to ascertain this type of information. And I guess to Judge Roberts' question, more to the point, why couldn't this information have been discovered prior to 2019 or whenever it was ultimately found?
Well, you got to remember what the jury investigator had to do. She had to look for the first name, the spelling, middle name, the initial, the last name had an E at the end, the date of birth. Mr. Davis would have no way of knowing any of that. Whether he could find it or not is almost irrelevant because he didn't. And generally, when you talk about newly discovered evidence, it's stuff on the record that was supplied in discovery, such as an affidavit of a witness or a recantation of a witness. It will be something that's generally part of discovery.
Well,
this would not be.
Right. Well, what if he had hired this investigative services 20 years from now? Would it be timely at that point?
It would be, because it's manifest injustice. As long as he files it within 2 years of finding out about it, it would be.
Okay.
Counsel, let me ask you about a practical problem. I mean, typically when you have juror misconduct, the judge brings the juror in and, questions him. I understand that can't be done here. How does that play into this?
I don't think it plays into it. If it had been one of the other misconduct, such as, like I said, a 17-year-old, or in Lowry, I think they did ask the juror some questions. In Martin, they asked the juror some questions. In this case, it doesn't matter. It is per se according to Lowry, it is per se that the juror is absolutely disqualified, and the defendant convicted of a panel that includes such a juror with pending charges is entitled to a new trial without showing any actual harm. It's per se harmful to have this juror on there.
Yeah, but Lowry was on direct appeal, correct?
It was.
It wasn't a post-conviction motion. We have a more recent case, Martin, laying out the standard that applies in a post-conviction, and the Supreme Court says more specifically in a post-conviction proceeding, the challenger must establish that the juror's misconduct resulted in the defendant being denied his constitutional right to an impartial jury. And to make that showing, the challenger must prove actual juror bias against the defendant. So how do we get around this case?
It does not. The Lowry case carved out an exception to it, which we meet. The Martin case doesn't even cite the Lowry, which was 20-something years earlier. It doesn't take that exception away. So Lowry is still good law. It's still the exception. And I agree. I don't think that you look at Martin and that overrules Lowry. Lowry is still good law.
So if I understand your argument correctly, to the extent that the foreperson failed to disclose criminal history, Martin would control. But here you're focusing on the foreperson's failure to disclose charges that were pending before the same court.
That's correct. I think that, and if the juror had passed away, if it had just been failure to disclose, then I think Martin would kick in. But it's more than just failure to disclose. It's the reason why is, and I think Thompson lays it out really well. Second DCA explains the rationale because the purpose of disqualifying a person who has a pending prosecution is to avoid the possibility that person might vote to convict in hope of getting more favorable treatment from the prosecution in this case. It's kind of like when the state has a trial and there's a witness, one of their witnesses has a pending charge. That's always relevant. The defense can always bring that out because the witness may want to curry favor with the state, and it could affect their testimony. Whereas if it's a defense witness and they have pending charges, well, that's not relevant because there's no reason to want to curry favor with the defendant in a jury trial, in a criminal case. So that's why Lowry is good law. There's Reese out of the third DCA, which followed Lowry.
I agree with you. I think Lowry is good law, but if it would have been on the direct appeal, I think there would have been a different standard. It seems to me that Martin does not overrule Lowry, but they do say that there's a different standard on post-conviction motions.
There is, but Mr. Davis could not have appealed anything because he was unaware of any of this issue. As soon as he found out about this issue, that this juror that he was not eligible on the jury, he was unqualified to be on there, disqualified to be on there, he filed a motion immediately. If he had waited a couple of years, there could be an issue. Then we'd have to look more at manifest injustice. But
Counsel, before your time expires, could you address the question of whether you're required to show that this information would probably have produced an acquittal?
I don't think under Lowry it matters whether it would have done it. It just goes to the fairness of the trial. And the fact that he did not get a fair trial, Mr. Davis did not, is really what's relevant here. It definitely made it more likely he was going to be convicted when you have a juror trying to curry favor, at least in his mind, curry favor with the state. When he's got prior misdemeanors, 6 misdemeanors, a VOP warrant, he's got all these charges pending, and he doesn't disclose any of them, he lies about it, that shows a bad intent on the juror's part. So, and he ended up being the jury foreman in the case.
If you don't have anything more, or if there are no questions from the panel, you can reserve the rest of your time.
I can
for
reserve
rebuttal.
the rest. Thank you, sir.
Ms. Piotrowski, did I say that right? Okay. You may proceed when you are ready.
Good morning, Your Honors. My name is Christina Piotrowski, and I represent the state in this case.
Would you move the mic just a little closer? There you go. That'll help.
So the state respectfully requests that this court affirm the lower court's denial of appellant's successive motion for post-conviction relief because it is procedurally barred and does not present a fundamental error or manifest injustice. The controlling case law is the Florida Supreme Court case Martin, which stated that a post-conviction standalone juror misconduct claim always presents a
Well,
threshold.
let's talk about the procedural issue first. I mean, I don't even know if we get to Martin, but appellant's counsel's argument was that the defendant was not schooled in the law and was not able to go down to the county courthouse and do the necessary research to find out that there was a record for this juror that the juror didn't disclose. So how should we handle that?
So the appellant is not able to show that he could not have obtained that information with due diligence. Being incarcerated or a lack of finances to hire an investigator does not mean that the information was not able to be obtained, particularly when all of the information came from the public records. So,
And there's no dispute that this information was in the public record.
correct.
And was he represented at trial by the PD, or did he have private counsel? What do we know about that?
I believe he had a public defender, but I will not say for sure that that was certain.
Yeah. And PD's offices have investigators.
Correct.
That investigate.
Correct.
Okay.
So under Martin, he has to first show timeliness, and under Florida Rule of Criminal Procedure 3.850 subsection B, that is where the requirement is that it needs to, the information or the facts that he relies on had to have been unknown to him and his attorney, and could not have been ascertained by due diligence. Now, he does try to compare it with the Supreme Court case Martin to argue that he does not have to show due diligence because he's presenting new evidence. But in Martin, that juror had a juvenile adjudication that could not have been discovered absent disclosure from the state or the juror himself. And so the court found that.
And you're talking about Lowry.
I'm talking about Martin.
Okay.
In Martin, there was the juvenile adjudication. The juror had a juvenile adjudication that could not have been discovered with due diligence because it could only have been discovered through disclosure from the juror himself or the state. In this case,
But the Supreme Court went on to Martin say that doesn't matter because there's a different standard in post-conviction proceedings, correct?
I'm sorry, can you say it again?
The Supreme Court in Martin said it did not matter that it was not discoverable because there is a different standard that applies in post-conviction proceedings, correct?
It did matter that it was not discoverable information because it went to the issue of the threshold question of timeliness. So he had to show in Martin first that he could not have discovered that information with due diligence, and he did show that because he could not have been obtained. Whereas
Because
here,
it was a juvenile and it's not in the public records.
correct, it's not
Okay.
in the public records, whereas here it is in the public record, and the jury could have been investigated at any time. Additionally, it's not as if, a juror kind of reached out to him 20 years later and was like, this is stuff that was going on in the deliberation room that you could have not possibly known about. He simply had decided approximately 20 years later to hire this jury investigator. And so to basically say that that overrides the due diligence would be to say that anyone could just wait and sit on their case for 20, 40 years and decide to go investigate it and find some new information and say, this is new evidence, and I could not have discovered this sooner. That is not what due diligence is. The information was in the public records. It could have been discovered, and he did not discover it such that he could have brought this as a timely direct appeal.
Counsel, assuming we get over the procedural, or the appellant gets over the procedural hurdle here, why doesn't the Florida Supreme Court's decision in Lowry control? Because the court in that case seemed to have carved out an exception, a very limited exception, where jurors fail to disclose that they have pending charges against them brought by the same office, which is exactly what happened in this case. So why wouldn't it be governed by Lowry?
It's not governed by Lowry because Lowry happens outside of the post-conviction context, and so it does not overcome the requirements that are specifically set out in Martin. And It
But
is.
Martin was limited, and Martin, you're exactly right. Martin was a post-conviction case, but it was limited to, and it says throughout the opinion, in cases like this, and like this is a post-conviction case where a juror fails to disclose certain criminal history. And again, in Lowry, and then the Supreme Court talked about this some in Boyd, that's different. That's kind of a different animal than when you have a case where a juror fails to disclose that he's under active prosecution by the same office.
So I would say the state believes that it's still distinguishable from Lowry, just because the certified question of whether a convicted defendant needed to demonstrate actual harm from a seated juror who was under criminal prosecution was answered with a qualified no. The Florida Supreme Court acknowledged the clear perception of unfairness that were in the circumstances of that case, which included that the juror received a favorable resolution to his case days after the resolution of the case, and the juror also spoke to the prosecutor in that case about his case and the case that he was sitting on the jury trial for in a single conversation. No similar evidence was offered in this case that shows a favorable resolution for this juror or that any perception of unfairness was truly in this case.
Was that an impossibility? It's my understanding from the record the foreperson has since passed away. Is it impossible to try to get the evidence that at least the Martin case seems to want to show the actual bias, meet the actual bias standard?
So in order to attempt to establish actual bias, the appellant could have called the prosecutor that was on this case, asked if he was aware of the situation, could have tried to have a motion to call other jurors and get more information about the situation. But I think what's most important is that had this been brought as a timely appeal, that's where you kind of get rid of these issues where 20 years later someone might be dead or the facts not as fresh in their mind or anything like that, because had this been brought as in a timely manner, it would be much easier to establish actual bias if it is there. But we just simply do not have the facts. In this case, there's way more facts in Lowry because it was brought as a timely appeal, and so we just do not have the same amount of information. Additionally, there's no exception in 3.850 or Martin for fundamental error or manifest injustice claims, and the state does not believe it can be said that a juror with misdemeanor worthless check charges with no evidence of actual bias or anyone at trial being aware of the issue sitting on the jury is an error so harmful that a verdict of guilty could not have been obtained without it, or that any manifest injustice would occur. So as the facts of this case could have been ascertained with due diligence and there's no fundamental error or manifest injustice, this claim is procedurally barred, and this court should affirm the lower court's denial. Thank you.
Thank you.
Timeliness. So newly discovered evidence has to be within 2 years of finding out about it. We've got that. Fundamental error is the validity of the trial is in question. Well, it's in question because you have a biased juror, someone who was unqualified. And that can be along with manifest injustice.
Well, there's a difference between being not qualified and biased. Don't you agree?
Well, biased for the state?
There's a difference between being biased and not being qualified under the statute to serve as juror.
We've got Mr. Cook both in this case. He's got bias, he's unqualified. So we really have both.
How do you know that?
Because he lied to get on the jury.
Well, people, they point out in Martin that there are other reasons people may lie when they're asked questions in open court about their criminal history because they're embarrassed about it.
And in Martin, that juror was able to explain that. In our case, he's not able to. So I think we have to go with that he was biased, and he's inherently biased for the state. When you're in Okaloosa County, you were arrested 11 days prior to this jury trial that you're going to be sitting on there. Your charge is pending. You have a plea day set in that county, in that same courthouse, and it had to be set off a couple weeks because you're sitting on the jury of Davis. And he ended up being the foreman, the leader of that jury.
But counsel, going back to the procedural question, which, and I'll be candid, that's what I'm struggling with the most with respect to your client's case. I mean, Martin talks about a due diligence requirement. It's not within 2 years after you just by happenstance find out, or, get the money together to hire investigative services to find out. Your attorney must, proceed with due diligence. How is that met here?
I don't think there's any way a defendant would know to look up these jurors. Due diligence to see if this juror had a pending charge. I mean, I think, with all due respect, this would be the first appellate court in the nation that would put a burden on defendants to look up jurors pending charges. There's no case that says that in the entire nation, and that's what the state is arguing in this case. He found out about it, luckily, and it's kind of like if it was an illegal sentence. He can raise it at any time, Your Honor. There's no other questions. Thank you very much.
Thank you, counsel.
All right. Well, thank you both for your argument. Both of you did a very good job. We have no other cases before us today, so we are adjourned.
All rise.